Illegally, they have taken the possession of the plot of land, my lord. They will
Therefore,
not-
this should have been filed, my lord. According to their
My lord-
allegation, they have been dispossessed, my lord, illegally. So therefore, this should
No,
have
they
been
will
filed.
dispose as illegally. They will whatever, my lord. That it means that a person who is following a law, he approaches the court, my lord, and on each and every ground.
Mr. Saikia, you are a very experienced lawyer and a competent lawyer. You will understand this. A stay of this order means allowing the appeal. So this court is definitely not going to stay. The only other way is to dismiss it if you press for it. You argue, contest it there.
Because I am, my lord, my case is against a very strong man, my lord, and my lord, MLA of a ruling party, my lord, and in my written statement, I had said no documents are there to show the possession, but we apprehended they will manufacture some
All right,
documents
you
and
argue.
submit.
You argue.
They have considered some documents.
He is entitled to say what
That is
he-
why, my lord. This is my lord. My learned senior is not aware, my lord, what is going on
Yes,
before
sir,
the trial
I
court.
was not the counsel there.
That is what
In this case, my lord, the suit was filed under section 6 of the specific Illegal Act, and we are the defendants. Along with that, they have also filed a petition under injunction petition. Initially, my lord, interim injunction was granted after hearing the parties' objection and all. That was vacated. However, parties were directed to maintain status quo. Having dissatisfied that, they have challenged that order before this honorable court, and this honorable court having found that the principles or the ingredients that to be considered while considering the petition under order 39 Note 1 and 2, those were absent. So therefore, the order was set aside and it was remanded back for a fresh adjudication. Now, the fresh adjudication has been made, but court did not follow or find the existence of the ingredients to grant injunction or not, my lord. On the basis of a decision of the Appeals Court, my lord, of 1983, it says the defendant has stated to be staying there, they will be staying, and the plaintiff, as they earlier were running a school, so they will be allowed to run. So, that is basically the case, my lord. Now, first of all, my lord, the earlier order was set aside because the ingredients were absent, the discussion on the ingredients were absent. So the court ought to have considered those ingredients. That was not done. And the case that has been relied on, it was totally on a different footing. There, my lord, total land was about 17,000 square feet or so, my lord. And the plaintiff had claimed only possession in respect of 8,000 square feet. So therefore, court's injunction will be only in respect of 8,000.
So trial court has refused injunction.
Trial court initially had refused injunction that was challenged before this court, and this court found that the trial court did not discuss the ingredients. That is the prima facie case, balance of convenience, irreparable loss. So as because those were not considered by the court, the order was set aside and then matter was sent back afresh. So now the same thing has been done without considering those ingredients. The injunction has been granted, and that too, my lord, certain documents have been submitted at a subsequent stage. After
now injunction has been granted. Where is the order? Let us see.
It is page 113. Lordship may come to my lord. Page 116, my lord, the contention of the defendants. Page 116, my lord, about 14th line from bottom, my lord. Has you also got it, my lord?
One minute, just 1 minute.
Lodge.
So basically a status quo till the disposal of the suit.
No, my lord. The order to the effect, my lord, the conclusion at page 123. Prayer for interim injunction during pendency of this suit is allowed, and the petitioner and the office, their men, agents, servants, and or other claiming through them are restrained from creating any hindrance in the smooth running operation of the Chandra Prabha Hazarika Vocational Institute by the petitioner and the family. The OPs are also restrained from creating any obstruction, hindrance in taking out dumper, etc. belonging to the petitioner's nephew from the suit property and from changing the nature and character of the suit property. The OP number 3, Lavanya Hazarika, is allowed to stay in the suit land, but she is restrained from carrying out any construction activities or creating any third-party interest over the suit property. After fulfilling the above condition, both the parties are directed to maintain status quo until disposal of the suit. This is accordingly disposed of. Here, admittedly, in the plain, they have said they have been disposed on 27/3/2021. It is also admitted that we are in possession of the suit land. So by the
right now, Mr. Saikia, you are appearing in this case.
Yeah, I am appearing for the caveat.
All the respondents.
Yes, ma'am. Well, the respondent is a family dispute. Only sole respondent is the other is because order 1 rule 8 represented. They are being represented. So all the respondents.
So we'll issue notice and fix it. What order else can be passed today?
And the status quo, my lord, as on today, my lord.
No. This is the order of July 2022. So wait for another.
But I am praying for status quo as on today. As on today. I am not anti, my lord. I am not asking. As on today.
Yes, my lord, this is an order. With all respect, I will submit, my lord. This appeal has not been filed bona fide, my lord. This is a mala fide, my lord. The order was passed on 8th of July, my lord. They do nothing, my lord. When we file an application for seeking police help only, then only this appeal comes up, my lord. And the area, my lord, is we have been dispossessed from a plot of land measuring about 37 square feet, the 2 bigha, my lord, or 3 katha odd lechas. Now, in that plot of land, my lord, we were operating a school in the name of this vocational training units, Chandraprabha Hazarika Vocational Institute, my lord. Now they have taken forcible possession. They are not allowing it. Before the trial court, my lord, their contention was that this respondent number 3, she doesn't have any place to reside, so it is that will be allowed to, she be allowed to reside. Then we have considered, my lord, okay, let her decide, but at least allow us to operate that school, my lord. Otherwise, it is having a my lord, public are suffering because they are. It is a motor driving school. They are taking training, my lord. So on that ground also, my lord, the honorable court said that, okay, the defendant number 3 be allowed to reside in that, and we will be allowed to operate that vocational training institute. And one of our dumper is also in that premises. They are not allowing us to take out that dumper. They are selling out. And before the trial court, my lord, what happens, my lord, when the matter is put up on each and every date, my lord, application comes out on this or that ground. Because of illness of the counsel or the defendants, they doesn't proceed with the suit, my lord. And when we go after getting this order, my lord, July, when we went into enter the premises, we were restrained, my lord. Filing no other alternative, we filed an application for police help. Then this appeal has been filed. So my respectful submission is, my lord, this is a plot of land measuring about 37,000 square feet. My learned friend says that status quo be maintained. The already is already there. That status quo be maintained. Allow us to operate that, my lord. Only this limited prayer is that allow us to operate that vocational training institute which was there, because we and they are also taking, my lord, changing the nature and character of the suit premises. Initially there was an institute. They have removed some desks, bench, and all those things. They have removed all the registers and all those documents. And even in their pleadings, my lord, written statement also they have said that on 20 previously they are saying that it was their father's or husband's plot of land, so they are claiming title. My lord, under section 6, my lord, law is very well settled that question of title need not be gone into. So then they come up with a argument that defendant number 3, who is the widow of their deceased father, she doesn't have any place. So we said, okay, let her stay, but allow us to operate and let the suit proceed. Ultimately, if the suit comes to a finding that they have been dispossessed, we have been dispossessed without following due process of law, my lord, law will take its own course, my lord. Now, by, my lord, granting an order of status quo, what purpose will be served, my lord? We are saying that let status quo be maintained, but at least allow us to run that institute, my lord. We only, my lord, Assam type, there was an Assam type 2-3 rooms institute, my lord. So
according to them, only on 23/2021, they have been removed, they have been dispossessed, they could not operate it, and they have also given few photographs, that again we have the objection where from it can be shown.
So
no, we are not going on photographs.
Objection to this order that the institution, vocational institution, should be allowed to run. You have
Yes,
objection.
the school does not.
Then we'll issue notice and fix it. That's all.
Status quo as on
Status quo will be subject to the condition that the vocational institution is allowed to operate.
No, my lord, can you see, my lord, here the suit is for specific performance of the section 6 of the
There is already a status quo order. Why you want another order?
my lord, on top of that, my lord, your lordship will say they will be allowed to run and operate the institute which does not exist there, my lord. It is a convention specific.
From their document only, my lord, they have submitted
exist.
selective documents, my lord. The document which we have filed along with the plaint, my lord.
How?
There only it was given that permission was given by the DTO to run that institute over that plot of land. Now, once they took possession, they have removed all the registers and everything. Now they are taking a ground that we have not produced registers and all those things. So, my lord, it's a vacant, my lord, plot 2 bigha 3 katha land around 37,000 square feet. allow us to operate that and institute, my lord, and let the status quo be maintained, let the suit be decided, my lord. My lord, they have illegally they have taken the possession of the plot of land, my lord. They will
Therefore,
not-
the suit has been filed, my lord. According to their,
They-
that is their
my lord-
allegation, they have been dispossessed, my lord, illegally. So therefore, the
my
suit has
lord, they
been
will
filed.
dispose
And
us illegally. They will whatever, my lord. That it means that a person who is following a law, he approaches the court, my lord, and on each and every ground.
So the matter will require in-depth hearing.
Lordship, hey, any day, my
And
lord,
trial court, my
as
lord,
on
on each and
they are
every date, my
voting to
lord,
enter-
some-
enter into the premises.
Mr. Saikya,
Lordship,
without having a full view of the issue, it will be
Lordship.
difficult to pass that on.
No, my lord, few things, my lord, at a glance I can show, my lord.
If you insist, then I'll consider, but then there is a possibility that the order will be rejected. In which event will it be suitable for your clients? At the
If your
moment,
lordship takes that view, my lord, I have, but then, my lord, here this suit itself is, my lord, for section 6 and it is an admitted on 27/3/2021, my lord. It is more than a year gone by, my lord, they have not been operating there, my lord. And by the order of injunction, what the final relief they have been claiming in the suit, that has been granted. They have been allowed
Finally,
to.
we are claiming recovery
They
of
have
one
possession.
minute, just take a, both of you can't
No.
argue. Mr. Saikya, what the court is proposing is, since the parties have already appeared, we'll fix a short date,
Lordship.
maybe towards the end of November or first part of December, and finish off the entire matter on a non-miscellaneous date. If you are agreeable with that, that order can be passed.
Till date, my lord, they are not operating, my lord, and therefore, my lord, they are resisting, my lord, that the status, I am not, my lord, I am not seeking status quo.
Mr.
ante, my lord.
Saikya, you have made your submission,
I am making.
but the order which was passed by the trial court in the month of July,
Lordship.
on the first day you want an order which practically allows the appeal.
No,
For that we have to, there is already an order of status quo.
no, in between my intervening period, the holidays, everything was there. This was also filed long back.
Then you are-
My only thing is that
I'm issuing notice on the appeal, and on this I'll dispose it of today itself. You'll argue the whole matter.
but what I basically wanted to show, my lord, this is an admitted that on 27/3/2021 they have been dispossessed. It has been, my lord, admitted there that we are in possession, my lord. It is an admitted fact, my lord, that they have, my lord, immediately after the, my lord, 27/3 they had preferred in, my lord, 145 proceeding. Though initially, my lord, the attachment order was passed, that was subsequently vacated, my lord. These things are there, my lord. And secondly, my lord, in the written statement, we have said that along with the plain, they have given as many as 10 documents. It does not
So,
show.
Mr. Saikya,
Much, my lord.
you are a very experienced lawyer and a competent lawyer. You will understand this. A stay of this order means allowing the appeal. So this court is definitely not going to stay. The only other way is to dismiss it if you press for it. You argue, because what remains in this appeal to, if this is
I'm
stay?
only praying for status quo as on today. I'm not asking for my status quo ante, my lord,
The
because
status quo would mean that the operation of the institution will again come to a standstill, for which we have to see whole view of the matter, what is the real issue.
and Lordship was saying that they have, my lord, it is stated they have, my lord, submitted application before the police, before the, my lord, court to give the police assistance to enter into the, my lord, the possession of the land. So in between intervening,
All right, what Mr.
that proceeding may be
Status
stayed.
quo subject to the condition that the operation of the vocational institution will not be interfered. That is the order will pass. But Mr. P.J. Saikya and his senior counsel appearing for the assistant vice chancellor appearing for the. You see, you want to stall the operation of the vocational training
It
institution.
is not there, my lord. It is not there, my lord. It is my.
Then why do you want a status quo order?
Because they are, my lord, as they have admitted, my lord, they have filed an application to, my lord, assist the.
Then you contest the
for police
application
assistance.
before the court below.
Well,
Why are you
they-
trying to get that thing overreached by a order from this court? You contest it there.
Because I am, my lord, my case is against a, my lord, very, my lord, strong man, my lord, and my lord, MLA of a ruling party, my lord, and in my written statement, I have said no documents are there to show the possession, but we apprehend that they will manufacture some
All right,
documents
you
and
argue.
will submit.
You argue. We'll
And,
hear.
my lord, they have considered some documents, my lord, what I am submitting, they have considered, the trial court has considered some document which were submitted after the High Court's order. The High Court passed the order, my lord, on, my lord,
So, Saikya, you are taking an undue risk. You want today itself everything should be done. That looks difficult. Anyway, you argue your case. Whatever you want to argue, I will hear it as long as you want to argue.
I seek a leave to produce before this court because the documents which we had filed along with the plain, those documents has not been filed.
Mr. Das, you do whatever you want. He has expressed some concern,
my lord.
and the court will definitely consider it.
Yes, my lord, we will
The
only take,
idea is not to shut him out,
no, no, my lord.
but the only
What-
point is, on the first day, we cannot decide these
No, no,
matters
I
without
fully
a
appreciate,
hearing.
my lord. My only prayer is that
If both of you want, we can hear it at 2.
at 2 also I am ready, my lord. Today also,
Final hearing, disposal.
if my learned friends insist, my lord, I am ready, my lord.
Final hearing, disposal today itself.
I don't have any difficult, my lord.
Because my learned friend is
But I am
insisting.
not insisting because it is court convenience.
The only thing I am saying is, without having a full view of the
Yes.
matter, I am reluctant to pass any order this way or that way. That's the point.
Yes,
Because this type of orders create further confusion,
yes, my lord.
more heartburning.
Yes.
That is the only issue. It's not that the court is not accepting his concern. So therefore, under any circumstances, matter will not be adjourned
Yes, my lord.
on the next day. Whether you want to, if you want to file any document, you file it well in advance
Yes, my
by
lord.
serving copy. Otherwise, we appreciate the urgency of the litigants.
Yeah, my lord. My lord,
We
we
are
also,
entitled to an
we also
answer.
appreciate, otherwise, my lord, what happens, my lord, once an order is passed, it is being dragged on, my lord, we wait there till 12:30, my lord, no one is present, my lord. Virtually, we have to send invitation to the other side, then a petition comes for adjournment, my lord. My lord, this is what, and my learned friend says that he is fighting against the mighty, my lord. My lord,
He is-
this-
he is
this is-
entitled to say what
That
he
is why, my lord, this is, my lord, my learned senior is not aware, my lord, what is going on
Yes,
before
sir,
the trial.
I was not the counsel there. But
That is
it
what,
is, it is,
so,
Is he not entitled to make his argument?
no, my lord,
Then-
but my lord, I am also, my lord, apprising your lordship, my lord, what is going
See,
on.
the
before
only
trial.
point is, the court appreciates that either of the party may have extreme urgency in the
Yes, my
matter.
lord.
The reason why I am not inclined to pass an interim order today is that without a full view of the
Yes. Lordship will
dispute,
decide of the entire
Yes.
matter, my lord.
nothing else.
Not-
It's
yes.
not to defer the matter.
No, my lord.
So there will be no adjournments
On
granted
that
on the next day.
Yes.
That we are making it very clear.
Yes, my lord.
He is also answerable to
Yes,
his
sir.
client.
We also have some urgency because
Yes.